is going to be 3-1.
Morning.
Morning. Do you want to, you're going to be the last person to come in, seeing your judge here. So, Michelle goes down there. In a minute.
But she's not, I don't know where she's gone.
Oh.
Don't move that chair, I'll have that placed
Sorry.
exactly how I want it.
It's like playing Tetris trying to get these judges in, isn't it?
These bloody courts are so small, aren't they? That's the trouble. They've got the screens up here, such as they are.
They don't do anything. They did a study and they said that, yeah, they're not. That was really well. Anyone getting
And the court on the end. One of the council got a thing yesterday and that was it. Everybody out.
What for someone testicle?
Yeah. So he's now gone into isolation. The court had to be cleaned, but not very well.
I bet.
Apparently. Not,
Well,
not to the high standard.
Nothing new there. Are we ready to get going? Okay.
Yes, Mr. Houseman.
Good morning, my lords. I'm here today together with Mr. Wilmot Smith on behalf of the appellants. My learned friend, Mr. Laney, together with Mr. Ruddle, appears on behalf of the respondents. This is my appeal, my client's appeal against the order of Mr. Justice Andrew Baker, made in December 2019, pursuant to permission to appeal granted by my Lord Justice Males in April of this year. My lords have the benefit, if that's the right word, of 2 rounds of skeletons on both sides. One of them yesterday from my learned friend in response to various matters. I will proceed on the basis that my lords have read and understood the contents of those skeletons and will do my best not to regurgitate or repeat them. What I was proposing to do was address my lords under 3 headings. Firstly, background. Secondly, the law. And thirdly, analysis. And the analysis, of course, takes account of both grounds of appeal. Depending on the meteorological conditions, I anticipate that flight path should take roughly 2 hours. First of all, can I just lay out the parameters of our discussion, or this appeal? And by that, I mean assumptions that are made for present purposes. If my lords take up the judgment that is under appeal, if I can put it like that. That's the core bundle, tab 9. And if I can direct my lord's attention to paragraph 9, which has 5 Roman numerals as subparagraphs, and invite my lords just to refresh their memory as to that. Those are, in a sense, the core assumptions made for today's purposes. I was going to say something briefly about 2 of them, and that is to say, Roman 1, there needs to be something of a health warning against Roman 1. Perhaps not so much for today's purposes, but in the event that the matter were to proceed to the Supreme Court at any stage, either on appeal from this appeal, or from some substantive appeal post-trial, if my lords were with me today, to the extent of overturning the judge's order below to allow this matter to go to trial and any substantive appeal that followed trial. And I say that because there's no binding authority on this court, and certainly not at a higher level, as to the recognition on the facts of a case or as part of the ratio decidendi of any decided case binding on this court for the imposition of a rescission trust, and certainly not upon remote recipients of the proceeds from the direct representor stroke contracting party. So that is at large. The non-party situation for a rescission trust is at large, if I can put it like that, at this level, there being no binding authority on my lords as to the existence of such a thing, and the existence of a rescission trust per se is at large at the higher level. Now, I only say that because everything said, obviously, is with that reservation in mind, so far as may be relevant. That's what I was going to say about Roman 1. Pausing there on Roman 1, of course, a great deal of the jurisprudence in this area actually arises in the context of equitable tracing, and one needs to approach the cases carefully to see whether what they are actually about and what the issue in the case was about was equitable tracing. Equitable tracing requires an equitable interest. The rescission trust only cases start out with something that we have all called a rescission equity. And when we come to the law, and as my lords probably already appreciate, a rescission equity is a mere equity, as it's described in the case law. What I would call an inchoate equity, what's sometimes called a proprietary power. It is, if you'll permit me a metaphor, a caterpillar or a pupa, spelt with a U, to use the Latin, and it only metamorphoses into a butterfly, i.e. an equitable interest, upon a certain event, a certain legal event. And that is the crystallization of the equity through rescission. And in a case where the only rescission sought and the only rescission granted and the only rescission that exists is a decree by a court, or in this case, arbitral tribunal, a decree of equitable rescission, that is the single legal moment or the single legal act whereby the inchoate equity is crystallized into an equitable interest. So that is an important feature, as you'll appreciate, of our analysis. It's something not to be lost sight of. It's something the learned judge below regrettably didn't deal with because he took a shortcut to his judgment, which we will look at. That was my comment on Roman 1. Roman 4 requires a brief comment, which is that for present purposes, and certainly emanating from the law of equitable tracing, there is what we could conveniently call the cash fiction, whereby proceeds can be traced through bank accounts, depending on the state of balance of each successive bank account at any given moment, into cash proceeds in another bank account, either in the hands of the original recipient, if he, or she, or it operated multiple bank accounts, or indeed in the hands of remote recipients, in the case where cash is transferred between bank accounts. So we're all operating today on the basis that the cash fiction is in play and makes no difference to our analysis. Two more matters on parameters. Can I ask you to take up the appellant skeleton? So it's core bundle, tab 2. And it's bundle page 23.
Just before you do that, going back to your comments on Little Roman 1, you say that the crystallization is the decree of rescission by the arbitrators. The respondents say, and I had understood from your pleadings, that you challenge whether the joint venture agreement has in fact been rescinded. So has it been or hasn't it been?
That's what I'm literally about to show, my lord. Yes, we accept that it has. Not in the pleading, and as I understand my reading of the transcript below, not below. but in this court it has always been accepted, and permission to appeal was granted on the basis that that was accepted. And this is an important point because, of course, it goes to mutuality. If you go to page 23 of the core, so this is paragraph 29 of the appellant's skeleton. Technically speaking, it was the applicant's skeleton because it was seeking permission to appeal. It's paragraph 29. If I could just ask my lords to read that with focus on the last 7 lines. Sorry, page 24. So I've actually given you a false reference. It's paragraph 30, small 2, on page 24. I do apologise. It starts as a matter of fairness. And it's that subparagraph with emphasis on the last 8 lines or so.